I think that was, Senator, an aspirational comment and one that, to your point, of course, I've said in my decisions, as you and I have discussed, that the march for racial equality is not finished, and we still have a lot of work to do as a country and as a people on that. So
I appreciate that. I really do. But I want to know what you were thinking in 1999 that would make you make such a bold aspirational comment that, hey, in 10 years, the court can view us all as one race. What was going on in the 1990s that led you to have that belief?
hope.
Okay, because you and I know, you and I are both aware of where the trends were going in the 1990s. This was the period where the drug war was in full blare, where the prison population exploded. Since 1980, we've been up 800% in the federal prison population. The massive increases in racial disparities of incarceration. Blacks constitute roughly 13% of drug users, but were 46% of those that were being jailed for drug offenses. Even our schools in the 1990s were becoming more segregated. And so your brief in the Rice case invoked Justice Scalia's argument that we should be, quote, one race. And this, let me go on with the Scalia quote, because he said that government can never have a compelling interest in implementing race-conscious programs that seek to address this nation's wretched history of racial discrimination. He said never. He said that race-conscious programs, I'm going to quote him now, are racial entitlement. Now, do you think that someone who wants to remedy the fact that they could not get a loan from the Fair Housing Administration because of the color of their skin is racial entitlement, or are they seeking racial justice? Do you think someone, a person who tries to remedy the fact that they were denied the chance to go to college under the GI Bill because of the color of their skin is seeking racial entitlement, or are they seeking racial justice? So to be specific with Scalia, do you agree with Justice Scalia, who you reference in your brief, that it's never permissible for the government to use race to try to remediate past discrimination, to try to achieve justice?
Senator, that was a brief for a client, first of all, so I was not saying something in my own voice particularly there, so I'm writing a brief for a client.
But if I can correct you, sir, you said it's just a brief for a client, but you seem to invoke Scalia's one race theory quite often. You invoked Justice Scalia's one race theory to a reporter. You again mentioned it in the Wall Street Journal op-ed you wrote around the same time. And you cited his opinion, yes, in this brief. Are you saying that you do not share Justice Scalia's beliefs about this idea that people who are seeking to address past discrimination, past harms, that they are seeking racial entitlement?
I think, first of all, the Supreme Court precedent allows race-conscious programs in certain circumstances. So the precedent on the Supreme Court, as you know, Senator, is different. I was writing a brief trying to cite all the principles from the different cases that would support the brief. But to your point, there's when you're trying to remedy past discrimination as a general proposition, you're seeking racial equality and seeking to remedy both past discrimination and the lingering effects.
So you disagree with Scalia that he says it's never permissible for the government to use race to try to remediate past discrimination to try to achieve justice. You disagree with Scalia?
The Supreme Court law.
I know what the precedent is. I know what the law is. I'm asking what you believe. Do you agree with Scalia that, again, that it is never permissible for government to use race to try to remediate past discrimination to try to achieve justice, that that's racial entitlement?
That position has never been adopted by
I'm asking what you believe, sir, not the Supreme Court.
Okay. The term I used was that what you're seeking is equality, equal, and what...
And right, so if you're seeking equality, I appreciate you grant that, is it never permissible for government to use race to try to remediate past discrimination?
There are a couple of things that the Supreme Court's pointed out in its case law.
And again, I know the Supreme Court case law. Maybe I can approach this in a different way. Okay. The aftermath of Katrina. In a case brought by plaintiffs in New Orleans who challenged the way government provided grants to homeowners as having a discriminatory impact on African Americans, you joined the minority in denying them relief. If the findings had shown that the grant program systematically disfavored African Americans? Would a government effort that uses race to remedy that disparity be unconstitutional? In other words, do you believe that all such efforts that the government using those efforts amount to what Scalia called a racial entitlement? I'm trying to figure out if you agree with that point that Scalia is making.
Senator, first of all, I approach questions like you are asking with a recognition of two things. One, the history of our country, and two, the real world today.
Yes.
And I try as best I can to understand both the history of our country on that issue and the real world today. So I'm coming at it from that perspective. You're asking a question, I think, about specific remedies for discrimination, and there's a lot. I'm a judge, as you know, and so I have to follow precedent, and the precedent allows remedies in certain circumstances.
And again, sir, I've heard you use that with a lot of my colleagues, and I know what precedents are, especially dealing with a lot of very important Supreme Court issues. I'm asking about your opinions because your opinions matter, what you've saved matter. Let me give you an example. In April in 2003, you wrote regarding a program designed to benefit Native American small businesses by saying the desire to remedy societal discrimination is not a compelling interest.
That's what the Supreme Court has said, and
Hold on, the Supreme Court said that the desire to remedy societal discrimination is not a compelling interest.
the Supreme Court has, let's go to Bakke, for example.
I'm going to get to Bakke.
Okay.
Just answer this question. Do you still believe, this is what you said, that race can never be used to remediate clearly proven discrimination? If it's clearly proven discrimination, I'm just using an absolute. Do you still believe that it can never be used?
Well, I think the Supreme Court has said it can be to remedy.
I know what the Supreme Court, but what do you believe, sir?
Well,
Come on, you know the history. You've recited it numerous times.
What I would say, look, I have trouble departing from the Supreme Court precedent and saying.
But you don't. You opined about it in emails. You've opined about it in Wall Street Journal articles. I've heard you opine about these things in race. You just can't say right now what you believe.
Well, a couple things, Senator, just to back up. Lawyer for client in the email you're reading as well. Lawyer
Christian
for
Science Monitor article, Wall Street Journal, your comments to a reporter. Let me approach it this way, because you're not answering the question, but let me see if I can approach it in a different way, now getting to some of the things you were talking about. The Supreme Court has said for decades, this gets us to Bakke. Yeah. The Supreme Court said for decades that institutions of higher education have a compelling interest in student body diversity, and that race can be used as a factor, not the only factor, but a factor in admissions if it is done so in a way that is narrowly tailored to serve that interest. You said, the court said this in Bakke, you and I know these cases, said it in Grutter in 2003, Fisher most recently in 2006. The simple question here is, do you believe these cases were rightly decided?
Senator, there are important precedents of the Supreme Court, and as Justice
I didn't ask you if there were precedents. I've heard you go through this before. Do you, sir, if you can't answer it, just say it, Corey, I can't answer this. Do you believe that those cases, you say Marbury versus Madison was rightly decided. You said that. You said Brown versus Board of Education, rightly decided. And by the way, desegregation cases could come before the Supreme Court. Do you believe that these cases, yes or no, do you personally believe they were rightly decided?
Senator, I am following the precedent of the set by the 8 justices currently sitting on the Supreme Court, and to put it in the terms of Justice Kagan, who was asked a lot of these same questions. It would be inappropriate to give a thumbs up or thumbs down on.
Yeah, but sir, there's a distinction between you and Kagan, you and Ginsburg on these issues, because let me just tell you the distinction.
Roberts, Alito, Gorsuch,
and I'm going to tell you the
Kagan,
distinction
Breyer.
between that excuse you're using with many of my colleagues. And the distinction here is none of those nominees had voiced personal opinions that government should refuse to defend these kind of programs. And let me give you an example. You wrote in an email about Adirondack versus Mineta, a case that involved benefits to minority-owned businesses. You wrote that the government should file a brief saying that the program is unconstitutional. And let there be no confusion, sir. You went on to write that, in fact, this is my personal opinion. And so you said that then. My question is do you still think a diverse student body is a compelling interest? You opined on it then. You wrote it then. Right. What do you believe now?
So a couple things there, Senator. First of all, the Adirondack case is in the context of contracting. The Bakke case is in the
So you think that those cases using race to remedy past discrimination is unconstitutional? That's what you wrote then?
Well, in light of the precedent of the Supreme Court representing a client in that case. And I go through, I think the email you're referring to, I go through, actually, we shouldn't, the SG should make a recommendation first that this should not be a White House dictated answer, and the Solicitor General is ordinarily, I think if you're referring to the email I'm thinking of, but in any event, I think, as you know, and I just want to reiterate, there's precedent in the higher education context, in the contracting context, that are somewhat distinct, and those precedents have been applied by judges. And my record on race discrimination cases, I'm happy to talk about my cases, the E.C. Ito, the
But you're not happy to talk to me about the opinions you've expressed in the past. Do you still hold those opinions now?
Well, that's what I wrote then as a lawyer for a client.
But you said that, again, that is in fact my personal opinion.
That's before the case is decided and
So
subsequent.
you expressed a personal opinion on this issue then. Do you still hold that same opinion now? That's unconstitutional.
I think you're taking, I believe, respectfully, personal opinion out of context. Their personal opinion about what the government position, so personal recommendation, because I said, the distinction there is I said the Solicitor General should first make a recommendation, and then the White House should respond, or the President. As to personal opinion, it was not my personal opinion, Kavanaugh. It was what the government's position recommendation would be based on President Bush's
Okay, sir.
stated
It
policy.
seems that you were pretty clear there what your personal opinion was.
Well,
Let me approach it again.
I don't want to.
Sir, we don't have to go back and forth. I want to ask you a simple, direct question. Do you think having a diverse student body is a compelling government interest? Do you believe that? Do you think having it's not a complicated question. Do you believe having a diverse student body is a compelling government interest?
The Supreme Court has said so, and my efforts to promote diversity, I'm very proud
But I know
of.
what the law is now.
No,
I'm
my
worried about
personal,
what the law is going to be, sir, when you get on the court and have the ability to change those precedents. But let me go back to your words. I just want to ask you about your words and maybe give you a chance to explain something else, because you haven't answered my question, and I understand that you're going to stick to that. You've also written that an effort designed to benefit minority-owned businesses, an effort to try to give them a fair shake because they had been historically excluded, and these are your words now, used a lot of legalisms and disguises to mask what is in reality a naked racial set-aside. That's what you said. That's how you referred to it.
what are you reading from, Senator?
Sir, I'm reading from an email dated August 8th. These are your words, but I don't need to know about
Can I get a copy of it?
You certainly can, but let's ask you what you believe now. I'll leave aside then. Yeah. Okay, you said it, but you wrote it, but my question is, what are your views right now? Do you believe that government efforts to promote racial diversity are a naked racial set-aside? Those are loaded words. Do you believe that now, sir?
The government efforts to promote diversity in the higher education context are constitutional, and I've made clear my own personal efforts to promote.
But you referred to it in the past, sir. You referred to minority-owned businesses trying to get a fair shake after historically being excluded. You call that which is very powerful.
I don't have the email, Senator, so I'm a little.
So have you ever used the term naked racial set-asides? Do you remember ever using that term?
That would, if you're saying there's an email, but I would like to see an email if I'm getting questioned about an email.
Okay, I'm going to ask my staff to provide you with an email while I move on.
I have promoted diversity in law clerk hiring and made a big difference in that.
Sir, you've told me about the diversity you promoted in law clerk hiring, and I'm so grateful for it. You've told me a lot of things about the diversity that you personally have practiced in your own life. I really, really appreciate that. I'm not asking you about the 5 black clerks that you have. That's good. You're seeking a position on the highest court in the land that's going to affect millions of people. Mm-hmm. You've expressed opinions about these subjects to the media, to the press, in speeches, in past emails, but you're not willing to say if you still hold those positions that you held before. And I want to just move on to specifically something that you have expressed opinions in some of your cases as well, sir, and that's the issue of racial profiling. You once discussed the use of racial profiling after 9/11 with your colleagues in the Bush White House.
Can I see the email?
What's that, sir?
Can I see the email?
Yes, I will get you the email, but there was
But I can't answer if I.
I'm going to ask you about your views now, sir, and I'll provide the email, but I'm more interested in your views right now, before you may be confirmed as a Supreme Court justice. There was a debate going back and forth And one of your colleagues said that there was a school of thought in the administration that if the use of race renders security measures effective, if using race renders security measures effective, then perhaps we should be using it in the interests of safety now, in the long now and in the long term. And that such actions, your colleague said, may be legal under such cases as Korematsu.
It sounds like you're quoting someone else.
I am quoting somebody else.
Well, it sounds.
Sir, I'm not going to stick you with that. I know you've already said Korematsu is bad.
Don't attribute.
I'm not attributing it to you. Sir, please don't accuse me of that. I'm not. I said that was your colleague. I clearly said that was your colleague. You did not respond in the email by denouncing racial profiling or expressing outrage at the idea of relying on a case as odious as Korematsu.
Mr. Chair, point of order.
Can I ask for my time to be paused, Mr. Chair, while you make this point?
Please do.
Please, pause, Senator Booker's
Mr. Chair, just as a
Yes,
courtesy to the witness, we just saw an example there where I even believe that the words that were being repeated were words in an email authored by Judge Kavanaugh. I think it'd be helpful if we could suspend for long enough to have the documents available to the judge so that he can be answered in proper context. Is that an appropriate request?
Do you have any objections?
I do have an objection. If my colleague has an issue with that agenda, I think he should bring it up after my time. I'd like to get back to my question.
Okay, let's proceed. Don't take time away from Senator Booker.
Thank you very much. Sir, your response to that colleague's email was that you generally favored race-neutral security measures, but you thought that there was, and I'm quoting you now, interim question of whether the government should use racial profiling before a supposedly race-neutral system could be developed sometime in the future. So it seems that you are okay with using race to single out some Americans for extra security measures because they look different, but you're not okay with using race to help promote diversity and equal opportunity and correct for past documented racial inequality.
Sounds like I rejected the racial profiling idea. What's the date? What's the date of the email, Senator?
The date of the email is January 17th, 2002. Mm-hmm. And so have you ever suggested or expressed an openness to, even in a temporary circumstance, like this email seems to indicate, in an interim question of using racial profiling? Have you ever suggested that, sir?
I'd like to see the email.
I will provide the email, sir, to you.
But it sounds from what you read like I rejected the concept, but I'll look at the email.
It seemed to me that you were open to the concept, sir, clearly. This is critically important because right now in our nation, there are law enforcement practices, and I think you're aware, that are overwhelmingly target African Americans and other people of color. Yet I've read opinions such as yours in the United States versus Washington that upheld a search, and I quote, in a neighborhood in southeast Washington, D.C. that you called crime-plagued, in Wesley versus District of Columbia, where you would have protected police from liability when they made warrantless arrests at a house that was in, quote, in east of the Anacostia River. You and I both know that those are predominantly black areas.
Yes.
Predominantly African-American communities.
Yes.
I understand there's case law that says police can justify some actions by saying that they were in areas that were high crime. But you know how some of these opinions, using this type of racially coded language, can further the disparate treatment of people of color with the police. And so the way I see it, and I'll give you a chance to respond, is that you're willing to consider using racial profiling and to accept police practices like heavy policing of African-American neighborhoods, but you're hostile to the use of race when it is used to promote diversity or remediate past proven discrimination.
Can I get 60 seconds?
Sir, go ahead.
Okay. On the Wesby case, there was a call to the police. It was not the police patrolling the neighborhood. In the Wesby case, the Supreme Court reversed the majority decision that had been written by other people that I dissented from. They reversed it 9-0 this past term. So what I wrote in Wesby, and I was cited, and the Supreme Court agreed with the approach that I had suggested 9-0. On the general concept, you and I have discussed this in our meeting. I'm very aware of the reality and perception of targeted policing or police activity in minority neighborhoods, and I try as best I can to be aware and understand that, and you and I talked about that, and the Wesby case, in my view, had nothing to do with that issue, and the Supreme Court.
Sir, I try to give you some time there, but this is what I'm hearing right now, sir. And you know, and I appreciate your rhetoric on these matters, but again, you're going to be a judge on the Supreme Court if you are confirmed and have a power to make massive differences in our country. And these are real issues. And so I asked you, was the Fisher case, I just asked if it was rightly decided. You refused to answer. I asked you again whether you believe diversity is a compelling interest. You didn't answer that, sir. That's not good enough for a nominee to the highest courts, particularly one who is expressed, and I'll provide you with the emails, as well as other quotes for the record as well, opposition to affirmative action and efforts to address systemic, provable discrimination, such as, and yet you also have an openness to racial profiling. And again, I'll provide that email. The cases I raise are about addressing documented systemic structural inequality in our country. This is about the fact that children in this country still encounter a different experience of America based upon the color of their skin and not the content of their character. They are more likely to drink dirty water and breathe dirty air and less likely to have access to equal educational opportunities. They're more likely to be stopped by the police. They're more likely to be shot by the police and become unfairly entrapped in our broken criminal justice system. Like you said you're an optimist. I'm a prisoner of hope, but even I have a troubling understanding in your eyes how America could be just months away or a few years away from becoming one race in the eyes of the law, as Scalia, who you've quoted numerous times. We are a good country with great people, and we're great people because people of all races in America have worked together. Black folks, white folks, all folks have worked together to make progress. But you said it yourself, we have so much work still to do. The Supreme Court, plays a vital role in that work, just as it did generations past with cases like Brown. And so, Judge, opportunities, you've answered my questions. I want to move really quick in the remaining time I have to voting rights, which is a crown jewel of the civil rights movement. It's designed to prevent states from putting up barriers for the rights of African Americans to vote. It's in the 21st century, voter ID laws, which we're seeing more and more, many people consider them the modern day equivalent of poll taxes. These laws are being enacted despite the fact that in-person voter fraud is incredibly rare. You're more likely to be struck by lightning in America than to find a person committing in-person voter fraud. You wrote an opinion in the South Carolina voter ID law that you said you were proud of that decision in my office, and I heard you say it here. I'm taking you at your word that you're proud of this decision. But you were aware at trial that the author of the South Carolina voter ID law admitted that he received an email from a supporter of the bill that said African Americans, that said if African Americans were offered a $100 reward for obtaining a photo ID to vote, it would be, and I quote, like a swarm of bees going after watermelon. In response to that racist email, the author of the voter ID wrote, and I quote him directly, "Amen, Ed. Thank you for your support." You were also aware that based on the evidence in that case that minority voters in South Carolina were 20% more likely than white registered voters to have a valid photo ID. So how could you have concluded that the voter ID law would not have a disparate impact on minority voters and poor voters in general? If a registered voter didn't have a photo ID, isn't it true that their only option was to write out a sworn statement that could expose them to criminal penalties? And isn't it true that even then they could only vote on a provisional ballot? Is that true?
So the decision was unanimous, joined by Judge Culler-Catelli, who's an appointee of President Clinton's, and Judge Bates, President Bush appointee. But it was a unanimous decision where we blocked implementation of the South Carolina voter ID law for the 2012.
So you're telling me things I know. Can you just get to your feelings on this? Couldn't you see
Yes.
that this was going to provide an impediment and disparate impact on African Americans? Couldn't you see the problems that this would create?
That's why we said that the reasonable impediment provision could not just be the form that they had prepared, but we essentially said what would have to occur.
And you said you were proud of me of the reasonable impediment provision. That's the point we had to stop when I talked to my office. Can I just ask you, because this is how I see the reasonable impediment provision. South Carolina tried to enact this law that wouldn't disenfranchise minority voters. When the people who enacted this law realized that they had to make changes to it, you remember this?
Yes.
They sort of created a second class of voters, those without an ID. They had to go to a separate line, fill out a form under the threat of criminal prosecution, wait for an attorney or a poll worker to witness that, and then after all that, they had to cast a provisional ballot that may not have counted at all. Now, this is a lot of a process, and you said to me, and I appreciate you saying this, you said what looks good on paper may fall apart in practice. And you told me, hey, Corey, I was keeping an eye on this to see what was going on.
I think I said senator, but yes.
Oh, sorry,
otherwise,
of course.
yes.
I'm sorry, Judge. I'm sorry. I feel sense of comfort with you. Can I just show you what was up in South Carolina polling places? You can see this sign. Here is a picture. This is a sign that was in the polling places in South Carolina after the passage of their voter ID law. I mean, look at this sign, sir. This is what people without a photo ID would have seen. This is confusing and intimidating. It doesn't show the what you call the reasonable impediment option that they had. It just shows this very thing. Do you see how this poster board, might not be really much of, I don't even know if you can see any reasonable provision aspect on this. It doesn't matter that the average voter seeing this poster could be intimidated by this process?
That's why I said in the last paragraph, the opinion, what looks good on paper may fall apart in practice. And what we did in the decision was we said, to your concern, I was concerned about the same thing you're asking about here when I was questioning the lawyers at oral argument. And we said the proposed reasonable impediment form wasn't good enough and that there had to be a catch-all box where you could put in any reason. Then we listed all the reasons.
Well, sir, I appreciate you saying all that, but this is the result. And let me go with something different from a person. You and I are nearly the same generation. I want to talk to you about somebody from a different generation that we all think is the greatest generation. They did try to get a photo ID under the law that you were a part of establishing that was upheld. And this is what it was: a 92-year-old South Carolinian named Larry Butler, a military veteran and a pastor of the Lord. He voted in the 2010 election, but in his attempt to get a photo ID, he had to chase down paperwork from his high school records, then go to get his birth certificate, then go to get court records. He went to the DMV, to the official vital records office, and the court. And after all that, actually, he still was having trouble. He still couldn't get a valid photo ID. According to the study by the Harvard Law School, the cost of his filing efforts were $36. That's how much all this process cost. Now, I'm not counting for his time. If he was working, it would have been a lot more. Yeah. And so I just want to ask you, because many people call this the modern-day poll tax, that we're going back. Do you know what the infamous poll tax was in South Carolina in 1895? Do you know how much it was?
The exact amount? I did not.
I didn't think, but I'll tell you, sir, it was $1. Yeah. That was the poll tax that you and I think is despicable and disgusting. It was $1 then, which is roughly $30 today, less than what it cost the veteran pastor, Larry Butler. That's less than what he incurred trying to get to vote after the 2011 law. And if it wasn't for him holding a press conference with the governor intervening and others giving him a special dispensation. And so here is this great generation where black folks and white folks in this country joined together. They fought and they bled, they died. Goodman, Cheney, and Schwerner dying for voting rights. They grew up at a time when the states like South Carolina routinely placed these burdens on the right to vote and made it impossible and even dangerous to try to cast these votes. I don't know if you see that this isn't that much different in terms of the cost to this person of trying to ultimately do what was in effect a poll tax. Now my time's about to run out, and I want to say you can answer up to this because I've only got 1 minute and 30 seconds. So let me just conclude, and then I know they'll ask you this. But this isn't complicated to me, sir. Costs like this create structural barriers that systematically disenfranchise African Americans, people of color, and actually poor people of all colors. I'm concerned that a person who believes that we are all one race, like Scalia says, in the eyes of government, that could happen months from now, a couple of years from now, a person who believes that efforts to promote racial justice are, your words, naked racial set-asides, that will be blind to the reality of someone like Mr. Butler and the experiences of poor folks all around this country. You refuse to answer a lot of my questions about your views of the race and the law, talking about what Supreme Court precedent is. We are at a time when states are enacting these laws all over our country, designed to disenfranchise voters. As one federal court said about a North Carolina law, targeting them with almost surgical precision to disenfranchise them. And now we don't even have the benefit of the Voting Rights Act provision designed to curtail discriminatory laws before they go into effect. Your answers don't provide me comfort. As a justice of our nation's highest courts, that you will fairly take into account the barriers that continue to disenfranchise minority voters like Mr. Butler today. Sir, I'm an optimist. I'm a prisoner of hope like you. But we have a long way to go. We have work to do. Black folks and white folks honoring the history of a united America fighting to make us more just. The Supreme Court has a vital role in that. And nothing you've said here today gives me comfort. Gives me comfort that should you get on the Supreme Court, that you will drive forward and see that we have that work to do and make the kind of decisions that will make a difference for people like Mr. Butler, people living east of the Anacostia River, north of the river, south of the river, all over this nation. Thank you, sir.
Can I take a minute to respond?
Sure, and then I'm going to recognize Senator Lee.
Senator, a couple things on that. I pointed out in the South Carolina opinion, I wrote the majority opinion, that we see on an all too common basis that racism still exists in the United States of America. The long march for racial equality is not over. I cited, I think you've seen, after an African-American hockey player scored the winning goal, and a burst of racial commentary about him, and that was just one of many examples I could have cited in that case.
Racial commentary can be more specific?
Okay.
Racist.
Racist.
I should have said racist. Racist comments is what I should have said online. And that was just one example I pointed to say the reality, just one example. I made clear that the reasonable impediment provision had to be rewritten. I was all over the real world effects during the trial that you're raising here. I was all over that. So were the other judges, of how's this really going to work in practice? How's it we drilled down and drilled down and drilled down and caused the rewriting of the reasonable impediment provision to make sure. I talked about the fact, for example, that African Americans in South Carolina at that time didn't have as many cars on the same percentage, and so to get to your point about getting the photo IDs, I made clear that I understood that. We blocked implementation for 2012 because we were worried, to your point about the form, that it wouldn't be enough time to get all this in place and to educate people. It was a unanimous decision. Again, neither side. The Obama Justice Department did not appeal our decision to the Supreme Court. I assume that's because they thought our decision appropriately accommodated the interests of the parties in that case and would ensure that African Americans in South Carolina were able to vote on the same basis as before. And talking about my life and record, and you were talking about that, going back to growing up, but the Law Journal note that I wrote on race discrimination talked about something that I know you've been talking about a lot, which was bias in the criminal justice system. And I said at the end of that Law Journal note that both racial equality and the appearance of racial equality were critical to the fairness of the racial justice system. I provided specific mechanisms for rooting out race discrimination in the jury selection process, and talked about what you've talked about, implicit bias or subconscious racism. I specifically talked about that in that decision. I've been I think, a leader. So there's a 2010 testimony before the Congress about the lack of minority law clerk hiring at the Supreme Court, and Justice Thomas and Justice Breyer were testifying before the Appropriations Committee, and they were asked about minority law clerks and the lack of them at the Supreme Court. And they said, in essence, well, we're hiring from the lower courts. And I remember reading that and thinking, well, I need to do something about that. I'm the lower court. I'm one of them. And so after that, I thought, what can I do? And I didn't just sit there. I went and thought, what can I do? And I started on my own going to the Yale Black Law Students Association every year starting in 2012. I think I'm the only judge who's done something like that, or certainly one of the few. And I just cold emailed them and said, I'd like to come speak about minority law clerk hiring because I'm told there's a problem there. And I showed up the first time wondering how it would go, and I explained, and I got a good crowd from the Black Law Students Association. I said, we need more law clerks. There's a problem, and let me tell you how to do it. And here's why you should clerk, and here's how you clerk, and here's how you, here are the classes you should take, and here's the things you need. And at the end of that meeting, I gave them my phone number and email and said, call me anytime, email me anytime if you want help. And then it was a big success. I got a lot of emails after that. I helped students get clerkships with other judges. One of them recently finished at the Supreme Court, emailed me thanking me for starting him on that road. And then it was a success, and I've gone back almost every year there. And as you know, we're graduates of the same law school. That's a lot of people clerk from there, so it's a good place to go. And I've continued to encourage African-American law clerks, but it's not just encouragement. I've given them help and advice and been a source of counsel. I've tried to be. And why is that? Because I saw a problem to the extent of the kind you're talking about. And it's one small thing, I suppose, but those are the future people who are going to be sitting around here and sitting here, I think. Those are the pool. And I've tried to be very proactive on that, including my own clerk hiring, where the old networks that prevented women and African Americans and minorities from getting law clerkships. I've been very aggressive about trying to break down those barriers and be very proactive on that, recognizing that part of this is professors who have research assistants. And so I've done my cases like the E.C. Ito case and the Ortiz-Diaz case, and I think the South Carolina case, I understand your concern about it, but I'm proud of what we did in that case. So I think if you look at your broader question about my life and my record, I understand what you're asking about a few comments in the Hawaii case. But if you look at the sweep of it, I hope it gives you confidence that I at least done my best to try to understand the real world and tried through my actual decisions to understand the real world and apply the law fairly, and through my other role as a judge and hiring law clerks to be very proactive in trying to advance equality for African Americans.
Senator Lee.
Sir,
Senator Lee.
Mr. Chairman, thank you. I think it's important, the rules of fairness and the rules of the committee require us to treat our witnesses with respect, with certain minimum standards of respect, such that you can't cross-examine somebody about a document that they can't see. Now, in this circumstance, the document that was referred to by my distinguished friend and colleague from New Jersey, Senator Booker, was designated as committee confidential. Now, there are ways we can deal with this. We can deal with this either in a closed session so that he can see the document to which you're referring, or we can also go about different procedures to make it public. We've already done this in this very set of hearings with Senator Leahy and with Senator Klobuchar, who identified some documents that were identified as committee confidential. The one thing we cannot do is refer to a document, cross-examine him about that document, but not even let him see it because he can't see it. We wouldn't do that in a courtroom, and we can't do that in our committee. Our rules don't allow it, so I would just suggest that we go through the proper procedure to either deal with this in a closed session or ideally go through the process that Senator Leahy and Senator Klobuchar went through in order to allow us to address this in open committee.
Mr. Chairman.
may I respond?
The objection is duly noted. 30 seconds, Senator.
I really respect my colleague from Utah, and I appreciate that. I'm not the first colleague that has referenced committee confidential emails, not the ones you said at the exception. They were referenced before, and that's why this system is rigged, is because we have been asking. I have letters here, sir, that have asked for. Now, the one email specifically entitled racial profiling that somehow, I mean, literally the email was entitled racial profiling.
But is that
somehow
for me?
that somehow was designated as something that the public couldn't see.
Yeah.
This wasn't personal information. This wasn't personal information. There's no national security issue whatsoever. The fact that we are not allowing these emails out, as we have asked, as I have asked, joined a letter with my colleagues asking, and that's why I'm saying the system is rigged. More than that, Senator, you have this system where there's whole areas of his career where he
Senator, if
discusses
you could
his
begin to
employment.
wrap up.
I will wrap up. Thank you, sir, for the generosity. Where there's whole areas where we're not allowed to let these out. And so I see you're outlining a process, but I'm saying that process is unfair, it's unnecessary, it's unjust, and it's unprecedented on this committee.
Okay. Gentlemen, I'm trying to be fair to everybody. I know Senator Lee wants to respond. With respect, if he would do that briefly, I'd like to continue on.
Senator Booker, I will go with you hand in hand, literally, to work with committee leadership staff to get that going. I agree with you. There's no reason why it shouldn't be something that we can discuss in public. I don't know why it was marked committee confidential. Wasn't in charge of that. Regardless, we do have to follow a procedure so that he can have access to it, so that he knows how to respond. I'll work with you on that.
Thank you, gentlemen.
Now that the
I'm
hearing's
next.
half over.
And I don't have an email. I want to start, I watched you for the last couple of days, Judge, and I want to compliment you on your demeanor. And I mean that. I know you're on your best behavior, but I appreciate your humility. We both know some federal judges who can pretty much strut sitting down. And I appreciate your attitude and your demeanor, and I mean that.
Thank you very much, Senator.
I just want to ask you a few questions about the law. I'm not going to ask you to violate the canon of judicial ethics. I'm not asking you to go thumbs up or thumbs down. I'm truly not. I may have to interrupt you a few times just to move us along. I'm not trying to be rude. I want you to understand that.
Sir.
You know, you have been nominated for the most powerful unelected position in the most powerful country in all of human history. Congratulations, but you understand also where we're coming from. There's no margin for error.
Yes, sir.
We've got to get this right. Yesterday, gentlemen, take it outside, would you? Yesterday, I talked a little bit about the fact that judges have limits on their power. And I don't know if I said it this way, but I said I think it's inappropriate for a federal judge to try to rewrite the Constitution every other Thursday to advance an agenda that either he or her supporters can't get by the voters. You agree with that?
Yes, of course, Senator. The judges interpret the law. They don't make the law, and that's obviously something that's repeated a lot, almost cliche, but it actually matters. If you keep that in mind, it matters.
Judges also have another duty, though. I didn't get to talk about it yesterday. Federal judges and state court judges have an obligation to protect inalienable rights, even if the majority wants to take them away. That's why they call them inalienable. And I said this when Judge Gorsuch was here. If you think about it, in many cases, the Bill of Rights is really not there for the high school quarterback or the prom queen. The Bill of Rights is there for the person who kind of sees the world differently, but has the right to do that. And I think that's important for a judge. Can we agree on that?
Absolutely, Senator. I think the Bill of Rights protects all of us, but that includes, and it's most relevant for free speech of the unpopular or the unpopular criminal defense.
Even if the majority says,
yes,
we're the majority, because we both know that sometimes the majority just means that most of the fools are on the same side. I mean, just because you're the majority doesn't mean you're right. Correct?
Just because you're in the majority does not mean you're right is absolutely a correct proposition.
Right. That's why we have a Bill of Rights.
Yes.
All right, I want to talk about, now that's the easy part. I want to talk about how we go about making these decisions, and there's a tension there, and that has to do with the language. If I talk about, and you've talked about it a little bit, but if I talked about the Holy Trinity doctrine, you'd know what I'm talking about, I'm sure.
Yes.
Okay. Now, the Supreme Court has rejected the Holy Trinity doctrine.
Right.
Okay?
Yes.
You talked about we're now textualists and are originalists, and you call the originalism constitutional textualism, I think.
Original public meaning,
Right.
originalism, constitutional textualism, I think those describe the same thing.
Okay. You start with the language. Let's take a statute, with the language in the statute.
Sir?
And the first question you ask as a textualist, is it ambiguous or unambiguous? Correct?
If there's a canon of construction that is there that depends on a finding of ambiguity, that would be the question. Otherwise, other than that, you would just see what's the best meaning.
Yeah, you read the statute.
Yes, read
And
the
say,
statute.
does it make sense? It either makes sense or it doesn't. How do you determine that? How ambiguous? You alluded to this, but how ambiguous does it have to be? Does it have to be 100% ambiguous?
Right.
Does it have to be 51% ambiguous? Is there really any principled way to compare clarity to ambiguity? Or do some judges use it as an excuse to get to those canons of interpretation about which they've already read in the brief to do what they want to do? Did you know?
Yes. So I've said many times in my cases and talks to students, the judges shouldn't be snatching ambiguity from clarity. So that's one thing. I think that goes right to your question. But to your broader question is, that's one of my concerns about a few canons of construction that depend on an initial finding of ambiguity, which sounds great in theory, which is, oh, if it's ambiguous, go to that canon or this canon or this canon. But in practice, over 12 years, what I've found, and I've written about this, is that there's not a good way to find neutral principles on which two, or in my case, three judges can agree on how ambiguous is ambiguity. And that's hard to even talk about with you. Oh, I find it ambiguous. I don't think it's ambiguous. And that is, in my view, frustrated the goal that I have of the judge's umpire, the even-handed application of neutral principles in the rule of law, and ultimately that's concerned me because some of these cases where that's come up are big deal cases, yet it's dependent on this initial determination that when you unpack it and you actually sit in the judicial conference room like I do, it turns out to be very hard to apply in an even-handed way. So that's been the concern I've identified.
I read your review article.
Yes.
You advocate the best reading of the statute. Okay.
Yes.
Okay, let's talk about that. And I want to talk about it not in terms of the statute, but the Second Amendment, and talk about the Heller case. You defined originalism as constitutional textualism, and the way to interpret the Constitution is to ask yourself, tell me if I get this wrong now, how would a reasonable person at that time have understood the Constitution? The public knowledge.
The original public meaning. I always want to
Public
add,
meaning.
of course, precedent is a huge part of what we do in constitutional law, but if you're looking at the words, the original public meaning, you look at what the words mean. Sometimes the meaning's changed, oftentimes it hasn't, but to your point, I agree.
And it's almost an objective test.
You're trying to make it as objective as possible, absolutely. It is an objective test. I mean, sometimes there's different evidence about what the meaning of the word was, I think.
Sure, but you're not looking at intent.
Correct. You're not looking at the subjective intent other than to the extent that helps show the
We've
meaning.
thrown that out.
Yes.
Okay, if you look at the Heller case, and I'm talking about the D.C. v. Heller by the U.S. Supreme Court, it wasn't a balancing case. You made that point clear at the Court of Appeal level. It was a text, history, and tradition case. And Justice Scalia wrote the majority opinion. Justice Stevens dissented, and they both took an originalist approach. And I went back and looked. Scalia, this is what he relied on. He relied on founding-era dictionaries, founding-era treatises. He looked at English laws, American colonial laws, British and American historical documents, colonial-era state constitutions. He looked at post-enactment commentary on the Second Amendment. And Justice Stevens, also using an originalist approach, looked at the same documents, and then he added, he relied on linguistic professors, an 18th century treatise on synonymous words, and a different edition of the colonial era dictionary that Justice Scalia used. Pretty impressive. Here's my question. Doesn't the originalist approach just require a judge to be an historian? And an untrained historian at that?
I don't think.
Wouldn't we be better off hiring a trained historian to go back and look at all of this commentary?
Well, the Heller case was one of the rare cases where the Supreme Court was deciding the meaning of a constitutional provision without the benefit of much, if any, relevant precedent. On most of the constitutional provisions, there's been a body of cases over time interpreting the provision, and you don't have to do the kind of excavation that Justice Scalia and Justice Stevens did in that case because it's been done before. The reason I think why the Second Amendment posed a challenge in that case in terms of figuring it out is the prefatory clause in the Second Amendment, which the question was that did that define the scope of the right indicated afterwards, the right of the people to keep and bear arms shall not be infringed, or did the prefatory clause merely state a purpose for which the right was ratified, and therefore you read the right as written, the right to keep and bear arms shall not be infringed. And to figure out what the prefatory clause meant, you had to figure out as a general proposition how legal documents at the time used prefatory clauses and what the purposes of those were, and that required a lot of historical excavation by the two justices who had the competing positions.
Okay, fair enough. Somebody commented yesterday, maybe it was you, Judge, they talked about how our judiciary was one of the crowning jewels of our government, and the fact that it separates us from other countries.
Yes.
I think one of the reasons so many of our neighbors in the world want to come here is because of our independent judiciary. They know their person, their property will be protected. I think that singles us out. You know, you never read about somebody trying to sneak into China. They want to come to America. But there have also been studies, I think Senator Booker talked about this, maybe it was Senator Whitehouse. People have, in America, many of them think the United States Supreme Court is a little Congress, that it's political. And that's unfortunate because that means we lose confidence in an independent judiciary. I'm not saying it's true, but perception is important in government. Do you think having cameras in the courtroom would help?
Senator, that's an issue that I've thought about. And let me just give you a little perspective on our court. We've gone to same-time audio in our court. We started with release of tapes much later, then release of tapes later in the week, then release of tapes later in the day, and now we're same-time audio in our court. And I think that's been that's worked at the Court of Appeals level for us. I know nominees who've sat in this chair in the past have expressed the desire for cameras in the courtroom only to get to the Supreme Court and really change their positions fairly rapidly. So that gives me some humility about making confident assertions about that. And of course, joining a team of 9 means thinking about that if I were fortunate enough to do so, in hearing the perspectives of why did they change their position, what's their view. I will say one thing about that I do think is important. Oral arguments are a time for the judges to ask testing questions of both sides, and there's a perception sometimes, and you see it in the media, that the oral argument, Judge X is leaning this way at oral argument. I really can't stand that kind of commentary about oral argument because I, at least, have always approached oral argument as the time to ask tough questions of both sides, and I do sometimes wonder whether people would get the wrong impression of oral argument. Now, I've always thought, too, though, the announcement of the Supreme Court decisions, when they issue the opinions, that's a different point in time when if there...
What did you say Justice Marshall said? People aren't fools?
Well,
you have to trust the people sometime, Judge.
And as to the decisions, right, that's when the court is announcing its decision, and that is the decision of the court. Oral argument, lawyers people are asking tough questions of both sides, and sometimes you would think, oh, Judge X thinks this because of the oral argument question.
I understand.
But the decisions, I think that's, let's put it this way, if I were starting, I think I'll stop there.
Well, I get your point, and there are good arguments on both sides, but I do think that the American people have lost confidence in the institution of the Supreme Court and Congress and the presidency. And it's ironic, given my generation, that the only institution that the American people I think have a lot of confidence in right now is the military, which wasn't true in my era.
Well, that shows.
But you know, you got to trust the people, and too many up here in the Beltway don't.
I agree with your general.
You know, they don't. The people don't read Aristotle every day, but they get it. They'll figure it out. All right, let me ask you a couple more. You're an originalist.
Did I pay attention? Yes, I pay attention to the text, the original public meaning, but informed. I always want to make sure I say precedent. If you're in a constitutional case, precedent is critically important, and that's part of the text of the Constitution.
Right, but the focus of primarily of an originalist is an understanding of the Constitution by the people, an objective test at the time it was written and ratified.
The meaning as opposed to the intent, and then informed.
Right.
I always have to add precedent.
I get it. I'm not trying to trick you.
No, I understand.
I couldn't trick you.
I just want to be clear in case someone takes something out of context.
All right, are you willing to overturn precedent that you think conflicts with the original public understanding of the document?
The Supreme Court's rules on precedent, the precedent on precedent, sets forth a series of conditions that you look for before you consider whether to overrule.
But I'm just asking you, if you come upon a case and you say, you know, I'm on the Supreme Court now, and I've looked at this, and that's not under originalism. That's not what the public understanding was.
So the first inquiry is the prior decision wrong, actually grievously wrong? And if you thought it was grievously wrong, that would be, you'd go on to because of that or for some other reason, you'd go on to the next steps of the stare decisis inquiry, but that's how that would work, if I understand the question correctly.
Okay. All right. Can we agree that there were state constitutions that preceded the federal Constitution?
They did, and the framers at Philadelphia drew on a lot of the experience of the state constitution.
They drew from state constitutions.
They sure did.
And can we agree that every state now has a state constitution?
Yes, and they protect a lot of rights.
Yep. In fact, before the federal Constitution was extended to the states through the 14th Amendment, the only protection you had from state government was a state constitution.
That's correct, other than the rights articulated in Article 1, Section 10 of
Right.
the original Constitution, yes. Ex post facto.
Can we agree that you're right under the U.S. Constitution? Let's take the Bill of Rights, but you know what I mean the whole
Yes.
document. Let's take the First Amendment. Can we agree that the First Amendment in the United States Constitution sets the floor, that the state counterpart, the state First Amendment counterpart, can actually give you a greater First Amendment right?
Correct, and I think I've mentioned a couple times Judge Sutton's book, and Justice Brennan wrote an article in the 1970s about state constitutional law doing exactly what you said and encouraging state litigants in state courts and state court judges to think about exactly what you're saying.
Well, and in fact, some states have. Like
Yes.
California, for example, their First Amendment, they don't have a state action requirement. Mm-hmm. Am I correct in that?
I will admit I haven't looked at the California Constitution recently, but I'll take your understanding of it, Senator.
Well, they don't. In a private shopping center, so long as it's a common area, somebody can go in there and protest, and you have a First Amendment right under the state constitution.
And the only question in that case would be if it conflicts with another provision of the federal Constitution.
And that's my question.
Okay.
That's my question. What happens when a state interprets its own First Amendment, which it can insulate from review by you guys, or by you soon-to-be guys on the Supreme Court, under the adequate and independent state ground doctrine, but it conflicts with your Fifth Amendment property right?
Well, Article 6 of the Constitution makes clear that the federal Constitution is the supreme law of the land, and that trumps not only state legislation, but also state constitutional decisions. So in that instance, the property right protected, if it were determined that what you're talking about violated the property right in the U.S. Constitution, that would control.
Except that's not what the United States Supreme Court said in the Pruneyard case.
Well, there was a,
Is it?
it was a balance, I think because they interpreted the property right not to be
A taking.
affected. But it,
But California won.
yeah, but the point being, and I think I had the premise, I hope I did in what I said to you, if you concluded that it violated the property protection in the U.S. Constitution, then the U.S. Constitution would control. In that case, the Supreme Court concluded that it did not violate the property protection of the U.S. Constitution.
I know I couldn't outsmart you. You're right. All right, you've got this First Amendment property, or this First Amendment speech right, free speech right on steroids in California. And there's no state action requirement. In Golden Gateway, Pruneyard, all, you know them,
Yes.
they all said it applies to a private entity, like a shopping center. I know that Justice Kennedy, I don't have the language here, but he's talked about how the internet is the new public arena. Okay. If you have, and other states have adopted this approach, same as California, this enhanced First Amendment right with no state action requirement. I think New Jersey has, and there's some other cases. How then can Twitter in California censor any messages? If you're living in California and you have a First Amendment right and it's not limited by the state action doctrine.
Senator, that sounds like a hypothetical I am not prepared to give you a full answer on, other than I'll give you a broader conception of
Well, it's coming.
right. So I think one of the things with these proceedings for judges and Supreme Court justice nominee hearings are backward-looking in terms of our cases, the cases I've done and the cases the Supreme Court's decided. But one of the interesting things that I think about is what's the future? What are the big issues coming down the pike? And
That's
so
one of them.
speech, how technology affects our conception of speech, how technology affects Fourth Amendment rights and our conception of search and seizure and privacy. I think on the war powers front, which I was discussing with Senator Sass and Senator Flake earlier, cyber war and how does the war powers framework fit in with cyber attacks? And I think those are three things, all technology rooted, that someone sitting in this seat 10 years from now are going to be, I think, critical issues. And I think we also think, again, backward looking, but what are the future crisis moments? Because there will be crisis moments for the Supreme Court, and usually those are unpredictable. When Justice Ginsburg and Breyer went through, you wouldn't have predicted September 11th, for example, or even thought to ask them questions about.
I'll stop you, Judge. I'm going to run out of time.
Thank you, sir.
I want to talk about Chevron deference just for a second. Here's my understanding of Chevron, the deference. First of all, the statute's got to be ambiguous. And if it is ambiguous, according to our Supreme Court, we've got to adopt the agency interpretation, even if it's not the most reasonable interpretation.
That's right.
It's just got to be halfway reasonable.
They say reasonable, but even your point was it's not the most reasonable.
It's not the most reasonable, okay? Here's what I don't understand. You look at the APA. This is what the APA says. I'm going to quote, "The reviewing court, not the agency, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action." There it is, big as Dallas. Now, that's just the court. How come we have to defer to a federal agency under 5 U.S.C. Section 706?
So, Senator, in my article that I wrote in the Harvard Law Review on this, I pointed out that statutory provision and did say that Chevron was in tension. I think I used something stronger with that statutory provision, but Chevron concluded what it concluded, and it's been applied over time. Now, I've pointed out some problems with it in terms of its practical application, the ambiguity trigger, and you're pointing out a problem at the core, which is where did it come from to begin with, given what the APA.
Well, not only that, Judge, but I mean, I know you know this, but it encourages misbehavior. And let's suppose Senator Whitehouse or Senator Lee, they run for president. You know, they're not going to go out and run on their good looks, though they're good-looking guys and all that, but they're going to run on policy. And then they get elected, and they meet us in Congress. And a lot of times they can't get their bills passed.
That's right.
So you know what they do.
Yes.
They go to one of their agencies, and they say, I'm going to take my policy, square peg, and put it in a round hole of a statute. And all we've got to do is find a judge to say that the statute's ambiguous, and then we can do anything we want to do. And that's not right, is it?
Senator, that's a problem I've identified in the real-world application of certain broad conceptions of deference, and that it's a judicially orchestrated shift of power from the legislative branch to the executive branch. And the phenomenon that you've described, I think, is exactly right. Presidents run for office. I've seen this when the president I work for, President
They all
Bush.
do it.
And that you get, and if you can't get legislation through, then you try to see existing statutory authorities where you can achieve, to the extent possible, your policy ends, and then you push the envelope on the theory of, well, there's ambiguity in the old statute, and then sometimes courts will uphold it, and that's...
Yeah, but your hands are tied when it comes in front of you. If a president does that, and all presidents have done it, I'm not blaming them. I mean, they all do it. But your hands are tied if the statute's ambiguous, and even if the agency interpretation is not the most reasonable, it can be the 10th most reasonable, and you've got to go with it.
So two things on that. One is if the statute's ambiguous, as we discussed, turns out to be a much more difficult inquiry. And footnote 9 of Chevron does say use all the tools of statutory
Right.
interpretation before you get to that, and that's something I've cited that, dozens and dozens of times, that footnote, to make sure that you're not jumping too quick to deferring to the agency.
Yes, sir.
Interpretation. The other thing is the major questions, major rules.
Could you tell me
principle.
quickly? I got 2 minutes.
Yes, that means if it's of major economic or social significance, you shouldn't defer to the agency because that's a big deal for Congress. And
I want to ask your opinion about universal injunctions. I don't know how many federal judges, district judges we have. 700, anybody know? 700. As I understand a nationwide injunction, sometimes they call it universal. It means that a single federal district judge can enjoin or freeze a law or a regulation. Let's suppose we have 700 federal district court judges. One of them can enjoin a law or a regulation. Thank you, ma'am. I just got an extra 20 seconds under the rule. Anybody else want to go? I'll get up to 40. I'm giving myself an extra 20 seconds. Where was I? Oh, yeah, the nationwide injunction. One federal judge can enjoin a law or a regulation for the entire country, even if every other judge in the country says, I don't agree. Now, what's the legal basis for that? It's got to either be a statute or the Constitution.
Senator, that is an issue that is being contested currently in courts around the country, I think, and is an issue of debate, and therefore, I think I better say nothing about it. I apologize for that, but it is an issue of current debate.
All right.
I apologize.
It's okay. I've got 9 seconds. No, I've got 29 seconds. All right, this is not meant to be a trick question. This question's not about Title IX, and it's not about sexual assault, because I know you can't answer that. But it's really well, I'm not going to ask that. I'm going to strike it. State action. Is a private security guard a state actor?
Well, as it stated, your question stated that way, the answer would be no, but I think sometimes the cases,
Couldn't be.
when you're if you're.
Okay,
there are
I'm gonna
questions-
take the note.
There are questions of contracting, and if you're a state contractor and this and that, there are
Well,
lots of.
here's my question, because I don't want to abuse this. I've always wondered this. If a city privatizes its entire police force,
Right.
they're private police officers, do they have to comply with the Constitution?
Well, that's why I pointed out the contracting issue that I mentioned. Some of the Supreme Court case law would say you look at the contracting issue, and I think that's an interesting question that's hard to answer in the abstract without looking at the particular arrangement of the particular city or locality and figuring out how much the state's involved.
Okay, thanks, Judge.
Thank you.
Senator Harris,
Thank you.
you want to take over?
Judge, have you ever discussed Special Counsel Mueller or his investigation with anyone?
Well, it's in the news every day.
Have you discussed it with anyone?
With other judges, I know.
Have you discussed Mueller or his investigation with anyone at Kasowitz, Benson, and Torres, the law firm founded by Mark Kasowitz, President Trump's personal lawyer? Be sure about your answer, sir.
Well, I'm not remembering, but if you have something you want to.
Are you certain you've not had a conversation
said
with
I-
anyone at that law firm? Kasowitz, Benson, and
Yeah.
Torres, which is the law firm founded by Mark Kasowitz,
Yeah.
who is President Trump's personal lawyer. Have you had any conversation about Robert Mueller or his investigation with anyone at that firm? Yes or no?
Well, is there a person you're talking about?
I'm asking you a very direct question, yes or no?
I need to know I'm not sure I know everyone who works at that law firm.
I don't think you need to. I think you need to know who you talked with. Who'd you talk to?
I don't think I'm not remembering, but I'm happy to be refreshed, or if you want to tell me who you're thinking
So
of who works.
are you saying that with all that you remember, you have an impeccable memory? You've been speaking for almost 8 hours, I think more, with this committee about all sorts of things you remember. How can you not remember whether or not you had a conversation about Robert Mueller or his investigation with anyone at that law firm? This investigation has only been going on for so long, sir. So
Right,
please
I'm not
answer
sure
the
I,
question.
do I'm just trying to think, do I know anyone who works at that firm? I might know.
Have you had, that's not my question. My question is, have you had a conversation with anyone at that firm about that investigation? It's a really specific question.
I would like to know the person you're thinking of, because what if there's
I
a
think you're thinking of someone and you don't want to tell us. Who did you have a conversation with at that?
I'm not going to.
Mr. Chairman, I'd like to raise an objection here. This town is full of law firms. Law firms are full of people.
First of all, I'd like you to pause the clock. Thank
The
you.
clock is paused.
Thank you.
Pause the clock. Let me raise
The
my
senator is
objection.
recognized.
This town is full of law firms. Law firms are full of people. Law firms have a lot of names. There are a lot of people who work at a lot of law firms.
Responsibility to all Americans. Vote no. Be a hero. Vote no. You have a responsibility to all Americans. Be a hero and vote no.
And-
Be a hero and vote no. Be a hero and vote no. You have a responsibility to all Americans. Be a hero and vote no. Be a hero.
Senator Lee.
On that point, law firms abound in this town, and there are a lot of them. They're constantly metastasizing. They break off. They form new firms. They're like rabbits. They spawn new firms. There is no possible way we can expect this witness to know who populates an entire firm that he's not even... My point of order, Mr. Chairman, is simply this. If there are names, if there is a list of names he can be given of the lawyers to whom she's referring, I think that's fine. But I think it's unfair to suggest that an entire law firm should be imputed into the witness's memory when he doesn't know who works at the law firm.
Mr. Chairman, Mr. Chairman,
Senator Whitehouse,
we had
are you making a point of order?
well,
Senator Whitehouse,
I'm trying to figure out what the rules are here, because we had a very, very long discussion about whether or not points of order were in order, because this is a hearing. And we were told that all of our points of order,
Senator Whitehouse,
all the documents.
there's never been a time in the 2 days where someone's made an inquiry of the chair where the chair hasn't recognized the member for a point of inquiry or a point of order.
And I've been
was one
recognized
of
now, and I appreciate that. But my point is that if the rule is that nobody on our side can make a point of order, then it ought not to be appropriate for Senator Lee to start making points of order after all of ours were summarily
Senator White,
silenced on the basis that we were in a hearing and not in an executive session. If we've moved out of hearing and into executive session, then I'm more than happy to make motions.
Senator
to
Whitehouse,
adjourn.
if the mere fact that you're speaking right now means that you've been allowed to make a point of order, the matter that you're talking about yesterday was a motion that the chair said was out of order because it was an adjournment motion that would have required us to be in executive session. Anyone who want to make an inquiry of the chair may do so, but we will limit it to that before we go back to Senator Harris.
Very good. That's the right result.
Sir, please answer the question.
I don't know everyone who works at that law firm, Senator.
And have you had any discussion with anyone ever about Bob Mueller and/or his investigation?
So you said Bob Mueller, so have
Or
I ever
his-
had a discussion about Bob Mueller? I used to work in the administration with Bob Mueller.
What about his investigation? Have you had a conversation with anyone about his investigation?
I'm sure I've talked to fellow judges
Anyone aside from fellow judges?
about Bob Mueller.
About his investigation, sir? I'll ask again.
But-
I asked the question just a minute ago. I'm surprised you forgot. Have you had this conversation with anyone about the investigation that Bob Mueller is conducting regarding Russia interference with our election or any other matter?
The fact that it's ongoing, it's a topic in the news every day. I talked to fellow judges about it. It's in our, it's in the courthouse in the District of Columbia. So I guess
And I'll ask
the
you
answer to
one
that
last
is
time.
yes. So the answer is yes.
Okay, and did you talk with anyone at Kasowitz, Benson, and Torres?
You asked me that. I need to know who works there.
I think you can answer the question without me giving you a list of all employees of that law firm.
Well, actually, I can't.
Why not?
Because I don't know who works there.
So that's the only way you would know who you spoke with? I want to understand your response to my question, because it's a very direct one. Did you speak with anyone at that law firm about the Mueller investigation? It's a very direct question.
Right, I'd be surprised, but I don't know anyone, I don't know if I don't know everyone who works at that law firm, so I just want to be careful, because your question was and/or, so I want to be very literal.
That's fine. I'll ask a more direct question if that's helpful to you. Did you speak with anyone at that law firm about Bob Mueller's investigation?
I'm not remembering anything like that, but I want to know a roster of people, and I want to know more.
So you're not denying that you spoke with
Well,
anyone?
I said I don't remember anything like that.
Okay, I'll move on. Clearly, you're not going to answer the question. When you and I met, we talked about race relations in this country, and there's been a lot of talk among my colleagues with you about the subject. And when you and I met, I brought up the incident in Charlottesville, where, as you know, there was a rally by white supremacists that left a young woman dead. You will recall that the president who nominated you described the incident by saying, quote, "I think there is blame on both sides." So I think this will be a simple question for you. Do you, sir, believe there was blame on both sides?
Senator, we did talk, and I enjoyed our meeting, and to talk about the history of this country, and we talked about that at some length, and talked about discrimination. I appreciated your opening statement yesterday where you talked about your experience. One of the principles I've articulated throughout this hearing is the independence of the judiciary.
And sir, I'd appreciate if you'd answer the question.
I am, Senator. So one of the principles I've talked about throughout this hearing is the independence of the judiciary. And one of the things judges do, following the lead of the Chief Justice and what all the judges do, is not stay out of current events, stay out of commenting on current events, because it risks confusion about what our role is. We are judges who decide cases and controversy. We're not pundits, or we don't comment on current events. We stay out of political controversy.
Judge, if you, with all due respect, I only have limited time.
But it's,
Are you saying that it's too difficult a question, or it's a question you can't answer, which is whether you agree with the statement that there was blame on both sides? We can move on, but are you saying you cannot answer that simple, pretty simple question?
I'm saying that the principle of the independence of the judiciary means that I can't insert myself into politics in either of two ways, commenting on political events or, in my view, commenting on things said by politicians, a governor, a senator, a congressperson, a president. I'm not here to assess comments made in the political arena, because the risk is I'll be drawn into the political arena, and the justices and judges of the
Sir,
United States.
and I appreciate your point. But there was such a robust conversation that happened, especially with my colleagues on the other side and you, about race. So on the subject of race, I raised this question, but we can move on. Have you ever heard the term, quote, racial spoils system?
Yes, and that is a term that sometimes is used to, yes, I've heard that term.
You twice wrote the term in the Wall Street Journal opinion piece describing the Cayetano case that you discussed previously with Senator Hirono. And I'll tell you, the racial spoils system, that term stood out to me, so I actually decided to look it up in the dictionary, the term spoils. And in the dictionary, spoils is defined as, quote, goods stolen or taken forcibly from a person or place. Can you tell me what the term racial spoils system means to you?
Senator, first of all, the Supreme Court affirmed the position that I had articulated in the amicus brief 7-2 in Rice versus Cayetano, an opinion written by Justice Kennedy. Second of all, the state voting restriction at issue in Hawaii was a state office, not for the Native Hawaiian.
Judge, that's not what I asked you.
But it
If you
didn't-
can define the term as you used it, what does it mean to you?
But I need to, you raised the case, and the state voting restriction in that case denied Hawaiians, residents of Hawaii, the ability to vote on the basis of their race. So if you were Latino or African American, you could not vote in the election.
And I heard your response to that earlier, and I appreciate the point that you made then. My question is, you used this term twice, and I'm asking, what does the term mean to you?
I'm not sure what I was referring to then, to be entirely frank. So I'd have to see the context of it. But what I do know is that the Supreme Court, by a 7-2 margin, agreed with the position articulated in the amicus brief, and that the voting restriction there was for a state office and denied people the ability to vote on account of their race. So it was.
Sir, I appreciate that, but you've been very forthcoming about the amount of work and preparation that you put into everything you do. You have certainly led me to believe that you're very thoughtful about the use of your words and your knowledge that words matter, especially words coming from someone like you or any one of us. And so I would like to know what you meant when you used that term, but we can move on. But I will say this, are you aware that the term is commonly used by white supremacists?
Senator, when I wrote that was 20 years ago in the context of a voting restriction that denied African Americans and Latinos the ability to vote in Hawaii. That I was representing a client when I articulated that, and the answer to your question is no.
Okay. Well, unfortunately, it has been, and it is something that you should know. You should know that the same year you wrote your op-ed, a magazine published a cover story, a magazine that is described as being a white supremacist magazine, published a cover story about what it called, quote, the racial spoils system, of, quote, affirmative action, the double standard in crime, sensitivity toward black deficiencies, and everything else. The same year, a self-proclaimed Eurocentrist wrote, quote, "While blacks are generally regarded as the recognized expert in the game of racial shakedown, it is American Indians who may actually be the real geniuses at obtaining, quote, racial spoils." So we can move on, but my concern is that this is a loaded term, and it would be important to know that someone who may very well and very possibly serve on the United States Supreme Court would be aware that the use of certain terms will have a profound meaning because they are loaded and associated with a certain perspective and sometimes a certain political agenda.
Well, I take your point. I would point out that Hawaii was denying Latinos and African Americans the ability to vote in a state election at the time, but I take your point and I appreciate it.
Thank you. In Griswold and Eisenstadt, the Supreme Court said that states could not prohibit either married or unmarried people from using contraceptives. Do you believe Griswold and Eisenstadt were correctly decided?
So those cases followed from the Supreme Court's recognition of unenumerated rights in the Pearson-Meyer cases earlier. And so what those cases held is that there's a right of privacy.
And do you agree, do you personally agree that these cases, those two cases, were correctly decided? So I'm asking not what the court held, but what you believe.
Right. So so to just go back to Pearson-Meyer, those cases recognized a right of privacy, the ability, one might say family autonomy or privacy, the term under the Liberty Clause of the Due Process Clause of the 14th Amendment.
And with due respect then, Judge, I'm asking, do you agree that those cases were rightly decided?
So I think
correctly
so in Griswold, I think that Justice White's concurrence is a persuasive application because that specifically rooted the Griswold result in the Pearson-Meyer decisions. I thought that was a persuasive opinion. And
Do you believe that it was correctly decided?
No quarrel with that.
Do you believe it was correctly decided? Words matter, again, words matter.
Yeah.
Do you believe it was correctly decided?
I think, given the Pearson-Meyer opinions, like I said, Justice White's concurrence in Griswold was a persuasive application of Pearson-Meyer. I have no quarrel with it.
So there's a term that actually both Chief Justice Roberts and Justice Alito used, I believe, and affirmed in their confirmation hearings that these cases were correct. And so I'm asking you the same question. Are you willing in this confirmation hearing to agree that those cases were correctly decided?
Given the precedent of Pearson-Meyer, I agree with Chief Justice Alito and Chief Justice Roberts, what they said.
That it was correctly decided?
That's what they said.
Do you believe the right to privacy protects a woman's choice to terminate a pregnancy?
That is a question that, of course, implicates Roe v. Wade, and following the lead of the nominees for the Supreme Court, all 8 currently sitting justices of the Supreme Court have recognized that 2 principles that are important. One, we shouldn't talk about, in this position, cases or issues that are likely to come before the Supreme Court or could come before the Supreme Court. And secondly, I think Justice Kagan provided the best articulation of commenting on precedent. She said we shouldn't give a thumbs up or thumbs down.
No, I appreciate that, and I did hear you make reference to that perspective earlier, but you also, I'm sure, know that Justice Ginsburg, at her confirmation hearing, said, quote, this is, on this topic of Roe, quote, "This is something central to a woman's life, to her dignity. It's a decision she must make for herself, and when government controls that decision for her, she's being treated as less than a fully adult human responsible for her own choices." Do you agree with the statement that Justice Ginsburg made?
So Justice Ginsburg, I think there, was talking about something she had previously written about Roe v. Wade. The other 7 justices currently on the Supreme Court have been asked about that and have respectfully declined to answer about that or many other precedents. It's all the, whether it was Justice Marshall about Miranda or about Heller or Citizens United. And it's rooted, I just want to underscore, it's rooted in judicial independence.
No, I appreciate that, but I'm glad you mentioned that Justice Ginsburg had written about it before, because you also have written about Roe when you praised Justice Rehnquist wrote dissent. So in that way, you and Justice Ginsburg are actually quite similar, that you've both previously written about Roe. So my question is, do you agree with her statement, or in the alternative, can you respond to the question of whether you believe a right to privacy protects a woman's choice to terminate her pregnancy?
So I have not articulated a position on that, and consistent with the principle articulated, the nominee precedent that I feel duty-bound to follow as a matter of judicial independence. None of the 7 other justices have, when they were nominees, have talked about that, nor about Heller, nor about Citizens United, nor about Lopez versus United States, Thurgood Marshall, about Miranda. Justice Brennan asked about
And
this.
respectfully, Judge, as it relates to this hearing, you're not answering that question, and we can move on. Can you think of any laws that give government the power to make decisions about the male body?
I'm happy to answer a more specific question, but
Male versus female?
there are medical procedures.
Okay? That the government has the power to make a decision about a man's
Oh.
body?
I thought you were asking about medical procedures that
No,
are unique to
I-
men.
I'll repeat the question. Can you think of any laws that give the government the power to make decisions about the male body?
I'm not thinking of any right now, Senator.
When referring to cases as settled law, you have described them as precedent and, quote, precedent on precedent. You've mentioned that a number of times today and during the course of the hearing. As a factual matter, can 5 Supreme Court justices overturn any precedent at any time if a case comes before them on that issue?
You start with the system of precedent that's rooted in the Constitution.
I know, but just as a factual matter, 5 justices, if in agreement, can overturn any precedent. Wouldn't you agree?
Senator, there's a reason why the Supreme Court doesn't do that.
But do you agree that it can do that?
Well, it has overruled precedent at various times in our history. The most prominent example being Brown versus Board of Education, the Erie case, which overruled Swift versus Tyson. There
So
are
we both
times.
agree. We both agree the court has done it and can do it.
There are times, but there's a series of conditions, important conditions, that if faithfully applied, make it rare. And the system of precedent's rooted in the Constitution. It's not a matter of policy to be discarded at whim.
But there's nothing, you and I agree, that prevents the court from doing it, meaning that it is not prohibited. The court is, if I may finish, the
Yes.
court is not prohibited from overruling or overturning precedent. No matter what the steps are that the court must take, the court may overrule precedent. And so my question also is, then, do you believe that this can happen no matter how long the precedent has been on the books? There's no, for example, there's no statute of limitations during which, after that statute of limitations is passed, the court may not touch precedent. Would you agree?
Well, for example, the Supreme Court this past year said that Korematsu had been overturned in the court of history. That, of course, was the case that allowed the internment of during World War
Yes,
II
yes, I'm
of
familiar with
Japanese Americans in the Supreme Court this past term. That was a 1942 or 3 decision in the
But
Supreme
you'd
Court.
agree there's no statute of limitations. The court can go back as far as it wanted if it believed it was warranted. There's nothing that prevents the court from reaching back many years.
What I would say is there are a series of conditions that the Supreme Court must
I
meet, and the age of a precedent, as I think the Supreme Court itself has articulated many times, does ordinarily add to the force of the precedent and make it an even rarer circumstance where the court would disturb an old
Thank you.
precedent.
Thank you. I have a couple of questions for you about voter suppression. Our history, as you know, is littered with shameful attempts to deny voting rights, especially for communities of color, and in particular the African-American community in this country. For 50 years, the Voting Rights Act has protected against racial discrimination in voting. I know you had this conversation, part of this, with my colleague, Senator Booker. Under the Act, it states that a record of discriminatory voting practices had to obtain federal permission in order to change their voting laws. I know you're familiar with that. But then came the court's decision in Shelby, and by a 5-4 vote, the court gutted the act, effectively ending federal approval requirement. The majority believed that the requirement had outlived its usefulness. As you know, that was part of the ruling, essentially saying that the threat of race-related voter suppression had diminished. So my question is, are you aware that within weeks of the Supreme Court's ruling, Republican legislators in North Carolina rushed through a laundry list of new voting restrictions, restrictions that disproportionately disenfranchised racial minorities? And it's just a yes or no question. Are you aware of that?
I recall reading about efforts in the aftermath, but one thing I would point out is I believe the Supreme Court's concern in that case was with the formula that was used for which states were covered by the preclearance requirement. I do not believe the court said that Congress was proscribed from going back and redoing the formula. So on the outlived its usefulness, I believe what the court said, I'm just describing it, not saying whether I agree or disagree, was saying the formula had not been updated to reflect current conditions, but was not saying that preclearance was precluded if Congress went back and adjusted the formula and studied current conditions.
Are you aware, as it relates again to that North Carolina action, that the Federal Court of Appeal later held that these restrictions intentionally discriminated against African American voters, targeting them, quote, and these are the words of the court, with almost surgical precision? Are you aware of that ruling?
When was that decision, Senator?
That was, I believe that was in it was shortly after, a few years ago, not 2016.
I'm aware that there's been a lot of voter ID litigation and other voting-related, election-related litigation in North Carolina, in particular, over the last several years. And so I'm generally aware of all the litigation in North Carolina.
And are you aware that Republicans in Texas, Alabama, Mississippi, Georgia, and Florida have also implemented new voting restrictions since Shelby, again, disproportionately disenfranchising minority voters?
Well, I know there's, I'm not aware of the specifics of all that, but I do follow election law blogs and election law updates to keep generally aware of developments in the election law area. It's an area.
Wouldn't you agree then, reading about this on the blogs, that it's troubling? In fact, compounding those with the recent proposal to close more than 2/3 of polling places in Randolph County, Georgia, where more than 60% of the residents are black. Wouldn't you agree that that's troubling?
I'm not aware of that specific, but as I had the South Carolina voter ID case, what I tried to make clear through the trial in that case and the opinion, which was unanimous, that the reality of racial discrimination in America exists.
Yeah.
The long march for racial equality is not over, and that courts must scrutinize efforts to look for discriminatory intent or discriminatory effects. Can always be evidence of an intent, and on certain laws, the effects themselves can be problematic.
And do you believe that the court in Shelby underestimated then the danger that states that was presented in terms of states' willingness to restrict the right to vote?
Well, I don't want to comment on I think that's getting to the correctness or incorrectness of Shelby in particular. I just want to underscore, at least as I recall the opinion, it did say Congress itself could adjust the formula for preclearance, and I don't think Congress has done so, but
And
that's
clearly unwilling to do it. So there will have to be some recourse, don't you agree, for those voters in these various states, if Congress is unwilling to act, to give them due process in terms of equal access to the polls so that they can vote. Otherwise, we're looking at widespread disenfranchisement. Wouldn't you agree, if Congress doesn't act?
So Shelby dealt with the preclearance requirement. There's still, of course, Section 2 of the Voting
Right.
Rights Act, which allows litigation brought by plaintiffs to challenge voting restrictions that are enacted with discriminatory intent or discriminatory effects as well.
Do you believe that Section 2 is constitutional?
I think that's asking me a hypothetical that about any statute.
Because you referred to it, I would like to know.
Well-
I would assume that you think it's constitutional if you think it's a tool.
Well, I think as a general matter, I don't want to pre-commit on any statute that you would identify. If there's some challenge raised, I'll of course listen to the arguments. But Section 2 is an important tool for the voting rights enforcement. The Voting Rights Act of 1965 is one of the most consequential and effective statutes ever passed by Congress in terms, and You know, I've said that, and the history is, of course, well known, but the voting rates before the 1965 Act were abysmal because of the discriminatory restrictions that were in place, and the immediate effects of the Voting Rights Act of 65 were enormous and are very important for people to understand.
I agree. And in fact, to that point, in his confirmation hearing in 2005, Chief Justice Roberts, when asked about Section 2 and whether it was constitutional, said, quote, "I have no basis for viewing it as constitutionally suspect, and I don't." Do you agree with Chief Justice Roberts that the law is not constitutionally suspect, or do you have a different view?
I don't have any basis for viewing it that way either. I was just, if you ask me about any statute, I want to be careful because I don't know what arguments could come up. And I always want to make sure I've preserved the judicial independence and have not pre-committed. But I agree, I have no basis for doing that.
And then after the president nominated you to the Supreme Court, you had a chance before now, it was the only chance actually before now, to introduce yourself to the American people. You stood in the East Room of the White House and you thanked the president for your nomination, and then immediately you said, quote, "No president has ever consulted more widely or talked with more people from more backgrounds to seek input about a Supreme Court nomination." Now, by my count, there have been 163 nominations to the Supreme Court. So unless you have personal knowledge about every one of these nominations before yours, including who those presidents consulted with and who they talked to, and I can't imagine that you have that personal knowledge. My question is, did someone tell you to say that?
No one told me to say that. Those were my own words. They were based on I did look into it a little bit in terms of thinking about what was possible before cell phones and before phones, and then thinking about the history. And I know some of the history of Supreme Court nominations, and I also know in that 12-day period, I do know that President Trump talked to an enormous number of people. I think President Clinton, when I look back on it, that's why I said no one done more. President Clinton, as I recall, had a consultation process that was very wide as well. But that was my analysis of the situation. Those were my words, entirely my words, and I thought it was important to point out because I was, as I said yesterday, I was deeply impressed by the thoroughness of the process during the 12 days, and I said as much yesterday, and I said as much in the East Room. The 12-day process was, at least it seemed to me, quite a thorough process.
Thank you. And then I'm going to follow up with some questions for the record for you on the first question I asked.
Okay.
Thank you. Thank you.
Judge Kavanaugh, you have been, we started this about 12 and a half hours ago. I'm amazed that you're able to continue to respond and compose yourself in the way that you have. I want to cover a couple of things, and I'm going to try and keep my comments limited so that we can get you, hopefully, with a decent night's sleep. A few minutes ago, you were asked some questions about emails or an email change that you were involved in, and you didn't get an opportunity to see them. You haven't seen them before. I hadn't either. As a matter of fact, when I heard them read, I thought, at least in one case, they were being presented as your words, and then come to find out, because you astutely asked a question, you found out they were actually somebody else's words. So I did look into reading them. There's a reason why you don't have them, and that's because they're clearly marked committee confidential. Senator Lee brought up the point when the gentleman from New Jersey was speaking that we would work hard to try and look and see if we could get those documents cleared. But I'd also point out that those documents were made available to everybody on this committee, any staff who supports the senator on this committee, on August the 22nd. And in the last confirmation process with Neil Gorsuch, Senator Feinstein availed herself of that courtesy to be able to look at documents and have them cleared. And in this confirmation hearing, Senator Klobuchar did the same thing. The reason why it's very important for members of this committee to honor the confidentiality requirements is because we become stewards of documents that were provided under the Presidential Records Act. Now we're going to go back and try and clear these documents. But I would encourage all my colleagues that if you haven't taken the time in the weeks that these documents were available to go through a process that Chairman Grassley has honored, please do so before you disclose such information before this hearing. So we'll see whether or not that information's made available. And I'll assume that Senator Lee will work alongside Senator Booker to see if that's possible. I also want to go back to Kaczynski for a minute, and you can actually take a break and drink some water because I don't really expect you to respond to any of this. I'm going to get to a couple of questions. You were asked about Judge Kaczynski. I think you were a clerk for him about 27 years ago, but you weren't allowed to answer those questions. And I'm not going to ask you about any of them right now, but I really want to kind of lay the groundwork for maybe where we can go with questions tomorrow. It's given me some food for thought on maybe where I'll go down that line if others do. You know, it's one thing for the people in the back to speak over you and make it difficult to hear, but I find it particularly insulting when members here ask you questions of what I consider an incendiary nature and really never give you an answer to respond. So here's a question I won't, maybe I will ask you this. Are you Judge Kaczynski?
No.
Okay. Because all of this was about somebody else's behavior for whom you clerked 27 years ago. You don't even have to answer that one. So some of my colleagues are arguing because you clerked with him and you knew him that you knew everything about him. Now, this is what's interesting to me. It turns out you're not the only judge that we've considered who clerked for Judge Kaczynski. President Obama nominated and the Democrats voted to confirm Paul Watford on the Ninth Circuit. He clerked for Judge Kaczynski. And actually, when the ranking member introduced him, she highlighted that fact. And as a matter of fact, Judge Watford, I believe, worked with Judge Kaczynski on the Ninth Circuit Court for about 5 years. I think that's right, about 5.5 years. So I don't want you to respond to this either. But if we're going to ask somebody who clerked for a judge 27 years ago, why didn't you know everything about that judge, then I think perhaps I would like to get copies of letters from members of the Senate here who should be sending letters to Judge Watford and asking him the same question. And now let's go a little bit further, because I think we've got some a double standard going on here. We had a member in the U.S. Senate faced with a number of allegations for sexual harassment by women. When those allegations surfaced, it even included photographs in terms of the behavior in question. And when reporters asked members about their thoughts on that and whether or not the member should resign, they said that's not a distraction that we should be dealing with here in the Senate. So I feel like tomorrow, if we go down this path, then we should be prepared to make sure that we fully explore the double standard and perhaps the questions that we should have for other people who worked with Judge Kaczynski. Now I want to get to Rice v. Catano, and I want you to go back very quickly. And the thing that you've said multiple times I think is very important because we've had a number of discussions here about Voting Rights Act and denying various people the right to vote. And this particular case, this case was about potentially denying people in the state of Hawaii the right to vote based on their ethnicity. Latinos, African Americans, Asian Americans. Can you tell me a little bit more about that and be brief? I'm going to try and be brief just so I can yield back some of my time.
Yes, it was the Office of Hawaiian Affairs, and it was a state office, however, and they restricted voting in that for that office and denied voting to people who were residents and citizens of Hawaii, but who were not of the correct race, and therefore African Americans and Latinos, and as you say, Asian Americans, whites in Hawaii were barred from voting for that office, and the Supreme Court held that that was a straightforward violation of the 14th and 15th Amendments to the U.S. Constitution.
And I believe you said by a 7-2.
By a 7-2 majority in an opinion written by Justice Kennedy.
Okay. Now I actually have to get to one fun thing that you may have to do some damage repair on. Yesterday, when you introduced Margaret and Liza, you told me that Liza, you end every night, she gives you a hug, you say she gives the best hugs in the world. Today, you mentioned to Senator Graham that Margaret came down and gave you a second hug.
She did.
So I was wondering if those competitive instincts are in play where she's trying to make up with quantity for quality.
It is possible, because I think I
I'm
said.
sure it was an act of love, but it could have been
Margaret is
competitive, too.
13 now, and when you're 13, the hugs are fewer and far between. But she
That's
came
right.
down last night, and it was very nice. She gave me a special extra hug.
And in the next couple of minutes, I want to talk about, we had people here talk about you being an advocate for big business, an advocate for the rich, that you would be somebody who would be beholden to your boss, or at least the person who nominated you. So I want to go back through in just a couple of minutes and talk about a few things that have been discussed, but I think they bear repeating, and I think that in the first one, we need to add a little bit of context. I was in the White House when the president announced your nomination, and I believe in that, in your comments, you mentioned that the first date that you had with your wife, Ashley, was on September the 10th. Is that right?
That's correct. September the 10th, 2001. Yes, the night.
And we know what happened the next day.
Yes.
And all the terrible events that you had to deal with, including your president, that you've said every day came in the office and said this can never happen again. And that was the culture for the whole time that you were in the office. So then you move forward a few years later, and you're on the circuit, and you do Hamdan v. United States. Now, you had personally experienced an evacuation in a building that you thought could potentially be at risk. You worked with a president who was personally very much invested in trying to protect the American people. And then you had this case. And in this particular case, tell me what you did.
The case involved Salim Hamdan, who had been an associate of Osama bin Laden's, and the case came to us through a military commission conviction. And the question was whether it violated ex post facto principles, and what that means was were you being convicted of something that was not a law in place at the time you committed the act?
I read your opinion.
Materials
Basically, you said
it was a violation.
right.
Yeah. So we reversed the conviction of Hamdan. In that case, I wrote the majority opinion in that case.
Incidentally, I mentioned yesterday, there's probably a couple of cases that I didn't like the way you ruled. That's one of them, but you did it for the right reasons. There's another one, Emily's List versus the FEC. Tell me a little bit about that one. We all know who Emily's List is. They proudly support promoting abortion rights and pro-choice Democratic women candidates. I went on their website today to confirm that that's still out there. Tell me what you did on that case.
They were challenging an FEC, Federal Election Commission regulations that prohibited how much money they could raise and how they could raise it, and I wrote the majority opinion invalidating those restrictions, and I wrote the opinion ruling for Emily's List in that case.
Another one, it's another one that I find interesting, didn't like it, but understand why you did it. Republican National Committee versus the FEC.
In that case, the Republican National Committee was challenging some restrictions on fundraising, donations to contributions to the Republican Party and Republican Party committees. In the wake of Citizens United, they were arguing that certain other aspects of McConnell versus FEC were no longer good law. I wrote the opinion rejecting that challenge and ruling for the Federal Election Commission against the Republican National Committee in that case.
I want to go back to another one. It involved another boss, actually a prior boss who was sitting right down there as the introducers yesterday. And that was Adams versus Rice. Tell me about that case.
That was a discrimination case involving someone who had had breast cancer in the past and was discriminated against in her job on that basis, and joined an opinion ruling that was unlawful discrimination and ruled against the government in that case. In that case, the Secretary of State in her official capacity, but the government in that case ruled against them.
And some have said that you're not for the employees, you're also big for the big corporations. Tell me a little bit about Stevens versus U.S. Airways.
That was a case where I wrote in favor of a group of retired airline pilots who were in a dispute about their retirement compensation with U.S. Airways, and I wrote an opinion favoring the the pilots in the litigation against U.S. Airways.
And, you know, if we go a little bit further, I think you already covered U.S. versus Norway, so I won't cover it there. But I think maybe one or two that I will ask you about. Tell me a little bit about your environmental cases, the American trucking case.
That was a case involving a California air quality regulation, and the argument by industry was that that regulation was impermissible under the federal environmental statutes and federal environmental law. And in essence, I'm simplifying for effect here, but in essence, preempted or impermissible. And I wrote the majority opinion rejecting the industry's challenge in that case, which allowed the California law to stay in effect. There was a dissenting opinion in that case that would have cast doubt on or invalidated the California regulation. I wrote the majority opinion sustaining it.
There were other people, and you know, I know that there were some in the crowd that expressed a concern about this, but there are some people here who suggested that somehow you're unfriendly to the LGBTQ community. If my information's correct, back as early as 2003, you participated in a meeting with some 200 members of the Log Cabin Republicans to solicit their input and feedback. And I was just kind of curious if you have any recollection of that meeting and really what prompted you to go there.
So as a member of the administration working in the White House counsel's office on judicial nominations in particular, but other issues as well, we would have outreach to groups, and one of the groups was the Log Cabin Republicans, and I went and spoke to them as a representative of the Bush White House to talk, as I recall, about judicial nominations. And I can't remember all the specifics. I might have talked about some of the other Bush administration initiatives and received feedback on that, and I do recall that.
Well, I'm glad you did that. I also think it's interesting, again, because some people haven't necessarily given you a chance to answer the question, but have suggested you'd be unfriendly to the LGBTQ community. The Human Rights Campaign ultimately put a statement out that said that, in fact, you've never been involved in any substantive legislation involving LGBTQ issues. Is that correct?
I don't believe I've been in any cases involving.
Lawrence v. Texas, Romer v. Evans, United States v. Windsor, Oberfeld v. Hodges, Bowers v. Hardwick. And they made it very clear that you haven't been involved in any of that.
Those cases were not through our court, and I'm not remembering any specific cases as a judge that I've had involving those issues.
Well, I would hope that if it comes up tomorrow, that perhaps they've found some evidence that you have, because we haven't. So I'm going to try and do what I did yesterday and be the member who spoke the least. But I'm going to do something a little bit different because I found out that I can. I am not going to yield back my time. I'm going to potentially reserve it for use tomorrow. But since I'm at the end of the dais, I'll probably be going last, and I probably will not. I just want to, again, thank you for being here. I want to particularly thank the people that have been sitting in the chairs. You've got the most uncomfortable position in the chamber, but you've got a far more comfortable chair than all the people sitting behind you, and I'm sure they're ready to get up. But we appreciate you being here. And I do also, I've got some wrap-up comments. I actually want to thank the members on both sides of the aisle because consistent with my old speaker self, I've been keeping a running total on exactly just how many people went over and how much time, and they did an extraordinary job given the complexity of the issue. And Senator Whitehouse, I'll add that technically speaking, you yielded back time, about 3 seconds. You may want to bring that in tomorrow. But I think it was a sea change difference in terms of what we saw here at the dais, and I think it's the right way to run these committees. So, Judge Kavanaugh, I want to thank you. I want to thank you for your patience. I want to thank you for your stamina. And the good news is you're more than halfway done. These were 30-minute rounds. Tomorrow will be 20-minute rounds, and I suspect that the chair will also ask members to try and stay within their time limits. So we'll be back here tomorrow morning at 9:30. For the information of all the members, we will stand in recess and reconvene tomorrow at 9:30 for the 20-minute rounds. Thank you.
Thank you, Senator.